because like even the statute that Tejwani is analyzing apparently changed a couple of years later. So like that's, you're going to be in big trouble trying to rely on that statute. But it's important because in essence, this statute, the Second Circuit held, contrary to what the BIA held in a published decision, that this statute of second-degree money laundering in New York is not a crime involving moral turpitude. And, you hear money laundering and you're going to be in big trouble. Usually it's a pretty serious provision. I'm currently doing an analysis right now for a case. I mean, there's no waiver for money laundering, and the CIMT provision's even less. So you would think money laundering is going to be a CIMT, but here's why the Second Circuit said it's not, and why it's important no matter what case, no matter what statute you're analyzing. It's because this money laundering statute in New York, the second degree, it requires knowledge of a crime and concealment of the crime. Okay? Oh, John, did you go away?
No, I'm here. I was doing videos.
It requires knowledge and concealment of a crime, but it doesn't require the specific mental purpose to conceal. So even though you have knowledge and even though you conceal, you don't necessarily have the intent to conceal or the intent to defraud. And that is what's required to be a CIMT. The quote is, a statute that, quote, provides that the intent requirement is satisfied merely by knowledge that the financial transaction is designed to conceal. It's not going to cut it. That's a paraphrase of a quote. And so it really, when you get these cases, CIMTs are hard, CIMTs are difficult, but it really comes down to what the mental state is, because state crimes, states, they're almost always going to try and over-criminalize, try to encompass as much conduct as possible, and try and have a lessened mental state or mens rea, because it's hard to prove specific intent in criminal court when the government has the burden. But that's really going to help us in immigration court, where we usually have the burden, the non-citizens, because if a statute is covering more than the specific intent to defraud, even just knowledge of criminal activity going on, you might not have a CIMT. And that's what David Kim just won at the Second Circuit in Jang v. Garland. So congratulations, David Kim.
A hardcore immigration lawyer is always like doing some crazy fighting. I don't know how he has the energy to always be on the front lines the way he is.
No, me neither. And I mean, I'll say it because I literally just saw him posted on Facebook. I mean, it hasn't been without casualties. He had a heart attack a couple of years ago, and I think part of it is from this. And that's just, more hats off to David. David's doing fine. David recovered, and he is still this fierce advocate. But, you put in the time, put in the effort. I say that not out of personal knowledge. Again, literally on Facebook, I just saw that he was referencing that happened to him a couple of years ago in relation to the stress from immigration lawyering.
For sure.
But bounced back for sure.
Well, good stuff. Well, thanks so much. What else we got?
Congratulations, David, Jang v. Garland. The other, I mean, that's the heady stuff. The other stuff is less so and just kind of maybe a bit amusing. Or I want to talk about Udo v. Garland in the Ninth Circuit. You and I are both in the Ninth, and I mean, it's not amusing, right? Because it's, it's about asylum. It's about an individual who was beaten for being a homosexual in Nigeria, and it was caught in a sexual act with his partner in this hotel. The amusing part to me is that he was caught in a lie about the name of the hotel during his removal proceedings. He said it was the Sinandi Hotel. I'm sorry, he said it was the Sheridan Hotel. And then DHS provided evidence that there is no Sheridan Hotel anywhere close in Nigeria. And he said, no, actually, it's called the Sinandi Hotel. And he just said Sheridan Hotel because he thought it would be confusing if he said Sinandi Hotel. I don't know, whatever. And the IJ, they made an adverse credibility finding and made a frivolous asylum finding. Like, so IJ threw the kitchen sink at the guy, but the Ninth Circuit came back and not only vacated the frivolous finding, which otherwise would bar him from receiving any relief in any context in the future, but vacated the adverse credibility finding as well, saying, quote, the name of the hotel where Udo and his boyfriend were allegedly caught is not a material element of Udo's asylum application, end quote. The location is at best ancillary. So again, according to the Ninth Circuit, even if he misspoke or even fabricated the name of the hotel, it wouldn't change the fact that he was beaten by a mob after being caught in a homosexual act and the other things. So the Ninth Circuit continues to have, depending on the panel, some very favorable, from some very non-citizen favorable adverse credibility standards. And that
Let me
applies
ask a
before
layman.
that applies before USCIS as well. I mean,
How,
go on.
how does the court make that determination? Aren't they not supposed to double second guess the fact finder's finding and stuff like that, or opinion and stuff like that?
Well, like all facts, it's subject to substantial evidence review. Not only that, I mean, this is what I talk about on the podcast all the time. When you're talking petitions for review, facts are substantial evidence review. You uphold them so long as substantial evidence supports them. But a legal conclusion, a legal determination, maybe a mixed question of law and fact, that's reviewed de novo. Is this a mixed question of law or fact? Well, maybe, because the Ninth Circuit has a very clear adverse credibility legal standard. And so if the BIA has not applied the facts to that legal standard correctly, that actually might be a legal claim. Credibility in the Ninth Circuit has gotten very interesting it's always been interesting, but after the Supreme Court's decision last term in Dye v. Garland, where the Supreme Court actually overturned the Ninth Circuit is now saying, okay, credibility determinations require a consideration of all the facts in totality. But as I read it, the Ninth Circuit is also saying, I've talked about this on your podcast, I think, before, if one of the things supporting an adverse credibility in totality was wrong under substantial evidence review, well, the whole totality fails. Because if there are three factors upholding something in totality, you take away one factor, now you have two factors. Well, now the totality might not support an adverse credibility finding.
So
it seems that
these asylum cases, when there's factual, determinations like that.
I'm sorry, what?
It's always good to appeal as much as possible in these kind of asylum cases if the judge makes a determination on on an issue like that.
Yeah, it's hard. But if an adverse credibility finding is made, no matter what the underlying relief is, but certainly asylum, you're probably going to lose. And so you kind of have to. And these become very tricky. And the Ninth Circuit is certainly leading the way on case law to challenge an adverse credibility finding again, be it before USCIS or the circuit or the immigration judge. Mm-hmm. And that does remind me to something negative that I didn't want to talk about, but I guess I have to. And that is our firm with Wilmer Hale did not succeed on the Patel decision.
That was your guy. You guys are fighting that one? Yeah,
that was. Ira was lead counsel, and a lot of people at the firm were working on it, and Wilmer Hale as well. Wilmer Hale argued it. 5-4, we got Justice Gorsuch and the historically progressive justices. To be honest with you, I was surprised. We were surprised. It's a long case.
Decision, a completely ridiculous decision, yeah.
It is, but putting aside the petition for review stuff, it probably kills challenges to USCIS denials in federal court. Probably does. It is, and so in that sense, it's huge and it's crazy. And so even if you can see that USCIS applied the adverse credibility standard incorrectly, for example, in the Ninth Circuit, you might not have an avenue to challenge that. It's a crazy conclusion, and it's one that the Supreme Court refused to reach in St. Cyr 20 years ago, but that it had no problem making now with a different court.
How far-reaching? Now, the podcast before this was an interview with Brian Green, interviewed Ralph Hua, and they talked about this. So they go into facts and that for viewers, but essentially, it's if USCIS or the immigration judge makes a error in a determination of a factual basis, and to me, it's a legal error what they were doing. So I'm not sure why that. I didn't read that. I only read the dissent. I haven't read the thing yet, the majority. But overall, it's just ridiculous. But Is this going to affect like if someone does an EB-1A and like they get denied and they go to federal court? Like, could this touch upon every kind of immigration case, or how does it look? Does that put you on the spot?
Probably. I don't know about EB-1A. For adjustment of status under 245A, it probably does, at least for the discretionary forms of relief.
Yeah.
There was already a problem with going to federal court because the jurisdiction savings clause funnels these things into circuit court rather than district court. It gets really confusing. But there was always this argument that for adjustment of status and other forms, but mainly adjustment of status when you're talking about USCIS, there was still review. But there's another statute that takes away review, and the jurisdiction savings clause for questions of law and questions of constitutionality does not necessarily apply to district court. It funnels it into circuit court. So in essence, at least with adjustment of status, if DHS decides not to put the individual into removal proceedings, which then puts a path to circuit review, eventually, if you just keep losing, then it might take away review.
Yeah.
No, it's crazy. It's crazy there. And with the circuit stuff, it's only about the specified forms of relief. Just adjustment of status is one of the specified forms of relief that the statute strips jurisdiction of, according to the Supreme Court. And so Mr. Patel, for example, there was a preliminary finding that he lied and that he intended to say he was a U.S. citizen on a driver's license application in Georgia. Now, even though that goes to whether he was admissible and doesn't even go to whether or not necessarily he's eligible for adjustment of status, just whether he's removable in the first place or whether he is preliminarily in need of a waiver, for example, because it was a factual question somehow related to adjustment of status. The Supreme Court 5-4 said that the circuits can't review the IJ and the BIA's decision. It makes it that much more important to win before the IJ and the BIA. Now, this doesn't apply to asylum, and mixed questions of law and fact remain reviewable. The Fifth Circuit just said that this week, and the Supreme Court's Guerrero-Lasprilla decision said it 2 terms ago. But no, it's a bad decision, and we're devastated. Didn't want to talk about it, but here I am talking about Patel.
I mean, it's an unbelievable decision, and it's like, could this be undone? They make another decision next year, like, because there's so many cases that where we touched upon this. But will the Supreme Court redo a decision they just made? It's 5-4, so it was close. I'm not a Supreme Court watcher that close to be able to tell you how this stuff works, but it's really messed up. It's really messed up, like what happened.
Well, Breyer was in dissent, and Breyer was just replaced by Justice Jackson. So I think you still have a 5-4 at a minimum.
Yeah.
And it's wonky. Congress can change it easy. It's all about the statute that Congress wrote. Congress could, and in response to St. Cyr, Congress wrote the 242A2D, the jurisdiction savings provision. So Congress knows how to react to Supreme Court jurisdiction decisions.
I mean, it's been a while since they were willing to do any immigration related. If they were going DACA would have been the way to go, like this, or there's myriad of stuff like that, or like look, it's Roe v. Wade. If they're going to do something like that, that shoe's going to drop. When is that supposed to drop? When does this come out?
There's a lot, and there's another immigration case coming down that might bar nationwide injunctions in immigration cases, and certainly might be. I mean, there's a lot going on. This is the Supreme Court we have for the foreseeable future.
Yeah, all the old guys, gals are. I mean, who else is led? It's refreshed. All the old guard seems gone. I don't think there's too many left over that were aging out.
Justice Thomas is the most senior individual on the court.
He looks pretty healthy.
No comment there. Just he has been on the court the longest. But in good news, I also want to talk before the last case is that last month there were 2 Cameroonian asylum cases from 2 different circuits, including the 5th, and both of them ended up sending it back. It's clear that something is afoot in Cameroon. I mean, I think people who know the country better than me already knew that. The Biden administration, I think, just granted TPS to Cameroon.
Yeah.
So we got circuits recognizing the terrible things are happening in Cameroon. The Biden administration doing TPS. So the Cameroonian asylum case is very much a thing. And there were 2 cases last month discussed on my podcast that, make it very clear.
Interesting. I mean, one thing about asylum is you learn in detail what's going on when you do these country condition reports and all these different countries. You're like, oh wow, this wild stuff are happening across the world.
One to speak. Our country has its conflicts, but I will say that to me, not knowing much about Cameroon, I might get hate for it. The conflict in Cameroon, at least the way it's described in these circuits, seems absurd. The French-speaking majority government is going after individuals who speak English as their primary language. And that just, of all the things to kill one another about. And don't get me wrong, apparently there was a faction of the English-speaking part of the country wanted to separate and secede. So, that's bigger than just speaking a different language, I guess. And I'm sure there's much more behind it rather than just language. But just if the impetus is different languages and people are killing each other, it really is. It's sad.
Yeah, that's why, like, people talking about like racism or stuff. I'm like, if there was no racism, people are gonna find a reason to do this kind of stuff. It's just how tribal the human nature is, and hierarchies and all that kind of stuff. It's too ingrained in our DNA.
You can't be more cynical than me, John, or else this is going to be the most cynical show you've ever done. You can't. One of us has to be non-cynical.
Well, we made it this far, humanity, and doing okay. We got technology, we see each other, and we can laugh and enjoy life. So there's, somehow or another, this chaos leads to some order on a plus side.
Which is a great way to go to the last case I want to discuss.
Let's do it.
Matter of BZR by Attorney General Garland, who could be issuing more decisions, but he's issuing ones like this. And Attorney General Garland has vacated the board's decision in matter of GGS. And matter of GGS had held that the particularly serious crime bar to asylum and withholding of removal cannot take into account the mental health of the respondent. So if you have a schizophrenic, Mr. GGS himself, if you have a schizophrenic non-citizen who throws a weightlifting weight at somebody else, hits him with it, the immigration judge cannot take into account the fact that he was schizophrenic and, has a mental health issue that could be maybe addressed with medication and stuff. That's what GGS said. Now, I know a bit about the background because that came out of the San Diego Otay Mesa Immigration Court when I was working there, and the immigration judge who issued that decision, she did not issue it in that way, and the board affirmed the immigration judge and issued a ruling that the immigration judge did not agree with. That is, that you cannot consider mental health evidence. But 7-8 years later, it turns out the board was not correct. Attorney General Garland has held the board was not correct because the particularly serious crime analysis focuses on board precedent, old BIA precedent. The primary focus is on whether or not the crime shows that the individual is dangerous. Mm-hmm. And if you have a mental health disorder, your crime might not indicate that you're dangerous. Depends on the facts.
Yeah.
Point is judges can be judges and they can consider mental health evidence in their overall analysis on whether or not a crime is particularly serious.
Yeah, that's what the judge is there for, take all these factors into consideration. So very interesting.
That's what Attorney General Garland held. The long fight on matter of GGS is over. And to end on a positive.
Well, how is Justice Garland doing on taking on cases? I remember in the previous administration, they were going and doing these kind of stuff. How active has Attorney General Garland been on this stuff?
He hasn't done much.
Yeah,
he hasn't done anything affirmative. The prior administration was very active in issuing decisions affirmatively. Matter of AB was defensive, essentially overturning matter of ARCG with the domestic violence, gender type, particular social groups, but almost everything else that the various attorneys general did under Trump was offensive, reinterpreting the law in a way that was adverse to non-citizens in a variety of ways. Attorney General Garland, I believe, has only issued 3 immigration decisions, maybe 4, and all of them have just been to vacate prior decisions. Vacate Attorneys General Sessions and Barr's decision in matter of AB and matter of LEA. Vacate the BIA's decision in matter of GGS. There might vacate Attorney General Sessions decision in matter of Castro-Tum on admin closure. So it's all been defensive. There doesn't appear to be any vision from the Attorney General on what he believes immigration law should look like, which may or may not be appropriate. I mean, there's arguments for the Attorney General to take a hands-off approach, although the statute clearly incorporates a view that the board and the Attorney General, it should be the Attorney General voice. But either way, when the prior administration, in 4 years, the Attorneys General issue 15 decisions.
Yeah.
If one side is being very active and the other side is not, then that does something to the law.
You mentioned the statute. I was thinking, like, when you're at the Federal Bar Association, was there commentary discussion about making immigration Article 1 core? Did they get into that at all, with the government lawyers being there too? Or
Yeah.
I imagine they discussed that a little bit.
Yeah, the panel didn't discuss it, but I talked about that with Betty Stevens, who used to be the FBA immigration section head, and who is kind of leading that fight and who testified before Congress. I talked to her again. I talked to her on the podcast, and I talked to her at the conference, and the FBA's sponsored bill has made it out of committee in the House, I think. Don't quote me on it. And so I guess it goes to the Senate, and then there's reconciliation. But they have gone further than ever in making immigration judges Article 1 judges, and the board. It's further than it's ever been. For better or for worse.
Yeah.
I think that there's good and bad for non-citizens in both. I tend to lean towards supporting Article 1 for a variety of reasons, but it does seem like there's momentum behind it.
Yeah. I'm interested in seeing I think it's the Office of Budget Management or something like that, OBM, like something that breaks down like the cost, because they're gonna have to create a whole court structure, and like immigration courts as they're usually like office rooms with like this stuff 50 people in. If it's the federal court, they have to like put infrastructure in there. It's just gonna see how that practically works out, but it just makes sense for that. The immigration courts as they are. Most immigration attorneys obviously pro that happening, but I wonder what downside there would be. Like be careful what you wish for kind of thing once it does happen.
Well, there is one. I mean, there's one downside. For example, I talked about this at length on the podcast. Check it out, Immigration Review, special episode with Betty Stevens. I mean, one of the downsides the FBA put in there is it would provide oil the authority to petition for review to the circuit. Currently, if the government, if ICE loses at the board, that's the end of it. The non-citizen wins. Yeah. Oil cannot petition for review to the circuit. But this, making them Article 1 judges, would provide DOJ that authority to petition for review to the circuits. For example, another, the greater, I don't necessarily subscribe to it because I worked for immigration judges who were appointed by all sorts of presidents and who had all sorts of backgrounds. But, it's no secret that the prior administration has appointed about 50% of the current immigration judges and more than that at the board, I think. And that a lot of them came with prosecution backgrounds, be it in federal court or at ICE.
Yeah.
And so before immigration judges get more power, there's an argument to be made that the bench should better reflect the practice of immigration law and not be so heavily biased towards a prosecutorial background. On the other hand, judges are judges. And quite frankly, the federal bench is also heavily weighed to prosecutorial background and I don't think many people argue that the federal bench is unfair. So I think that maybe I'm naive, maybe I'm a romantic, but I think putting on the robe brings out the best in individuals.
I have to read
They
the
try to
bill.
get past their background.
There's a big issue of a lot of federal benches constantly being empty, and then presidents coming in. They have to keep there's just a lot of empty seats that got to be approved by the Senate. And so it's like, are they going to? I have to read the bill, but are they going to make it easier to choose immigration judges? Because there's going to be a lot of people to be chosen. Obviously, there's this 1.5 million backlog, so they need tons of judges all of a sudden. Are they going to have the difficulty of approving it with the same standard as a district judge or something like that? Or are they going to have? Are these going to be a different kind of Article 1 judge? I should say Article 1. They have to be able to consent to the Senate kind of thing.
I also talked about this with Betty. I had a similar. You gotta listen, man. You gotta listen. You're showing your cards. You didn't listen to my stuff.
I'm making a note to make sure I watch it. I'm very interested now.
She said that the president is going to nominate, and the Senate will, I don't know, I guess confirm. It's not the same as Article 3 judges, but only the board members, I believe. And then the board members will be able to then appoint under Article 1 all immigration judges. So you're not going to have 600 immigration judges going to Washington. It's only going to happen with the BIA members who are currently sitting in Falls Church anyway. Something like that.
Okay, I'm not sure that's much better than what we have right now, because the BIA, it could go either way based on the makeup of the BIA. It could go massive directions here or there.
Well, there's still and the Attorney General gets taken out completely of this equation, by the way, once they become Article 1. That is also a thing.
The employee of the Justice Department as a judge, it doesn't make any sense. So you have both the prosecutor and the judge both on one team. It's not in part. That part of it never made any sense to me. Probably doesn't make sense to the judges either.
I worked for UIR under the Obama administration, and I saw no collusion between IJs and DHS, and I did not get that feeling. In fact, some IJs I knew and worked for were harder on ICE than they were on the private bar. But I lived the last 4 years under the Trump administration just like you, and did see things that seemed to undermine the independence of immigration judges. So
even their own union said as such, controlling their docket, all this kind of stuff. So not necessarily collusion, but it's just at the end of the day, it's that they're employees of the Justice Department, so they're controlled in a sense. They don't have the independence that judiciary has. So that's
why I tend to lean towards making them Article 1 judges, even though I might not agree with, I don't know, the majority of current immigration judges. I don't know, maybe I do. But even though I would feel better if somebody who didn't want to build a wall had been the one who appointed 50% of the immigration bench, maybe I'd feel better about it. But I think long term, if you raise the bar, you make everything more formal, I think that it helps everything in the legitimacy of the court. Maybe it's naive.
There's some court packing possible with the BIA too, because they don't have the restrictions on the number of BIA judges. So we worry about the Supreme Court, but they could be court packing the BIA and then choose. The
prior administration did pack the BIA. Yeah. They expanded and they packed the BIA. It's not something that's talked about nearly enough.
Mm-hmm. So it's politics is such a wild game. But thank you so much for coming on the show again. Very interesting stuff, and you don't get to talk about this with anybody. So with Weston, it's immigration. It's hard finding places to have these kind of discussions, but I'm glad we were able to have them here, and hopefully you'll enjoy it. We have some comments on this software. I don't think who the person is, but someone said, "Go David," a reference to David Kim, great at immigration journey, and nice beard, John. Thank you so much for watching. I appreciate it. We're gonna draw it out. When I was a kid, Madonna was the biggest singer, and every year she would reinvent herself and have a new style and this new hair colors and that. So my family hates that I have a beard, but I'm like, listen, I got to reinvent myself a little. Let me grow a beard for the rest of this year, and then we'll try something new. Who knows? I might color my hair green or blue or something next year.
You heard it here first, folks. John Khosravi is the Madonna of immigration law. He's the Persian Madonna, if you will.
Sounds good. Thank you so much. Stay on the line. We'll talk a little bit after. But thanks everyone for joining. Check out the Immigration Lawyers podcast or Immigration Lawyers magazine, the Toolbox magazine at immigrationlawyerstoolbox.com. Probably this issue, next issue, Kevin or one of his colleagues at his firm is going to be having an article. So looking forward to that. Yeah, check out the magazine. It's pride and joy. There's a lot of work that goes into it, and trying to figure out how to do it and with the practice is hard. But I really appreciate everyone who's accessing it, reading it, enjoying it. All right, bye everybody.